Okay, good morning, everybody. We'll get started since we're at the top of the hour. I'm Alex Terlecki with the Colorado Special Districts Pool. Just want to thank everybody for our membership joining us today. I see everybody's found the chat box, chatting through. Glad to have everybody here from diverse special districts and organizations that support us. Thanks for joining us again. This webinar today is on sexual harassment prevention. This course is going to provide you with information you need about sexual harassment prevention in the workplace, whether that is in the office, in the field, or even remotely. This content focuses on what constitutes sexual harassment, how to promote a respectful workplace, and how to report harassment in the workplace as well. Today's presenter is Alice Baker. We're very thrilled to have her here today. Alice is a licensed attorney who specializes in labor and employment litigation. She's been a full-time faculty member at both the Mercer University School of Law and the University of Toledo School of Law. And Alice is the author of several published articles. A few housekeeping items to discuss. Per usual, we're recording today's session. If you need to step away or have technical difficulties, we will send out a copy to you via Eventbrite, the same type emails that you were getting to access the link for today's session. There's a PDF version of today's slides available for download in the files box above the chat box, and you can share that and distribute that great handout to peruse this information after the presentation is over. And then we'll also be taking questions too throughout the presentation. If you have them, go ahead and type them in the chat box. Pause at the end for another final Q&A. And if you have any if you need any assistance with audio, sometimes that's localized to our users, so just go ahead and log out and log back in, and that should help correct any issues. But again, recording will be sent out afterwards, so if there's any major issues, there's a remedy. So with that, I'll turn things over to Alice, and she'll detail where we're headed with today's discussion. Alice, thank you.
Okay, good morning all. Thank you, Alex. It's good to be here with you today. My name is Alice Baker. As Alex said, I'm a lawyer. I specialize in labor and employment issues, and particularly in employment discrimination. So we have three general objectives today. We're going to learn some of the federal and state laws governing sexual harassment. We are going to learn some of your obligations once a sexual harassment complaint has been received. And then we're going to talk generally about some of the proper procedures for reporting sexual harassment. I won't give you anything that is specific to your agencies, but I will tell you the general rules for what you would do in those cases. Let's start off by introducing the classes that are protected, or the groups of people that we're talking about. We call this class sexual harassment prevention because that's what state agencies and employers tend to like to call it. But I do want to make you aware that everything we're going to say today applies with equal force to 14 categories of people who are protected under either federal law, Colorado state law, or both. And I've given you this slide. I've divided them into four general categories. Ancestry, so we've got race, color, national origin, and ancestry. Things related to physical conditions, age, disability, and that can be either a physical disability or a mental disability, by the way. Genetic information. We have sex, so categories: sex, sexual orientation, gender identity, gender expression. And sex, by the way, includes not just biological sex, but as I say, also things like gender identity, gender expression. It also includes pregnancy, childbirth, breastfeeding, anything like that we might associate with one biological sex or the other. And then there are some, I just called it association for lack of a better word, kind of a catch-all category for everything else: religion, creed, which includes, by the way, lack of religion, and military and veteran status. So those are the 14 classes that are protected under, as I said, either federal law, Colorado state law, or in most cases, both. So we're going to say sexual harassment, but it's really race, color, religion, national origin, yada, 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 yada harassment. A lot of people are surprised to learn, in fact, that if you look for a sexual harassment prevention statute under federal or state law, you won't find it. What you will find is something like Title VII of the Civil Rights Act of 1964. This is the big grandparent of them all. The federal statute, Title VII, which makes it unlawful for an employer to fail or refuse to hire or to discharge any individual, or, and here's the money language, otherwise to discriminate against any individual with respect to his compensation, and then again, money language, terms, conditions, or privileges of employment, which includes not being harassed because of such individuals. And then you get this laundry list of categories: race, color, religion, sex, national origin. So it's not a sexual harassment prevention statute. It's an anti-discrimination statute that applies to 5 separate categories of people. If you look at the Colorado anti-discrimination statute, what you find is the same thing. The Colorado anti-discrimination statute makes it unlawful for an employer to harass during the course of employment any individual because of, and then you get this laundry list of categories, one of which is sex. So just be aware of that. We're not just talking about sexual harassment. We're also talking about harassment on the basis of race, color, religion, disability status, and several other things. I'm going to touch on and then drop just one general comment, just so that we know we've covered it. And this is the 2 general forms of that discrimination can take in the workplace. And we divide them into job status discrimination and hostile environment discrimination or harassment. Job status discrimination is the one that we won't be talking about today. It's still illegal. It's just not the subject of today's conversation. So job status discrimination is discrimination that involves official action by the employer: hiring, firing, promotions, demotions, training opportunities, mentorship opportunities, employee discipline, holding employees to different standards of performance based on their membership in a protected class, wages, hours, other terms and conditions of employment. So my shorthand for this one is it's the discrimination that hits you in the pocketbook. It doesn't necessarily have to hit you in the pocketbook or the bank account, because it also includes things like being given unusually onerous shift assignments or the worse office or something like that. But generally, we're talking about things that can affect the bank account. I'm mentioning that one just briefly to say that's not the subject of today. It's illegal, but we're not talking about it. What we are talking about is hostile environment harassment hostile environment discrimination or harassment, which in the workplace usually exists as a form of employee misconduct. It doesn't have to. It could involve official action by the employer. Theoretically, your employer could declare we're going to have official sexual harassment Tuesdays, but your employer does not do that. Usually, it's an employee who's breaking the rules. They're violating the employer's policy against discrimination and thereby engaging in employee misconduct. Now, another possibility, of course, is that the misconduct is being committed by someone other than an employee. So a random member of the public who accesses the services of your agency, and that can also give rise to unlawful employment discrimination. But hostile environment discrimination is bad behavior, unwelcome conduct that is severe or pervasive enough to create a work environment that a reasonable person in the victim's demographic shoes would consider to be intimidating, hostile, or abusive. Now, when you were told that you were being sent to your mandatory sexual harassment prevention course, you probably got a picture in your head of what sexual harassment looks like. And if you are like most people, the stereotypical picture that you get in your head is straight out of the old movie 9 to 5, where Dabney Coleman is chasing Dolly Parton around the desk. We have a male harasser. We have a female victim. We have an imbalance of power. It's supervisor against subordinate, boss against secretary. The harassment is motivated by sexual desire. We have a harasser who is attracted to the victim and is expressing their attraction in ways that are not appropriate. And it generally has sexual content. I invite you to consider for a moment how many of these stereotypical elements of sexual harassment are necessary in order for the victim to have a valid claim. And the answer is going to turn out to be none of them. Consider, for instance, my dog, Lady. When I was growing up, my family had a dog named Lady who was not a rocket scientist among dogs. And we never figured out what triggered this behavior in Lady, but every time she saw a man wearing a hat, she went ballistic and started to bark her head off. We have here conduct that doesn't match any of the stereotypical elements of sexual harassment. We have a female harasser. The dog is female. We have male victims. She only barks at men. The power imbalance is completely in the opposite direction. Lady's not the boss. She's not a peer. She's not even human. She's a poodle. She is not motivated by sexual desire. She's motivated by animus, by hostility. She does not have any sexual content. Her barking, in fact, indicates, I'm not happy with you. I don't like you. Go away. Get rid of that dumb hat. Nevertheless, despite the fact that none of the stereotypical elements of sexual harassment exist, I have a dog who has chosen to mistreat men based on their status as being male. Now, this is what we sometimes call sex plus discrimination because it's man plus hat. But as long as she's only barking at men and not at women, I have a dog who is a sexual harasser who needs to remain out of the workplace. I can't bring her in safely. I got a sexually harassing poodle. What is the point for your perspective? Well, if you're a supervisor, keep your eyes open for sexual harassment that might not meet the elements of the stereotype. We'll move on now to the easiest question of the day: who is protected? And the answer turns out to be everyone. Employees are protected. Job applicants are also protected. You don't actually have to be working there. Unpaid interns, independent contractors,
Hi, everybody. Just wanted to interject real quick. We did lose audio with our presenter. We're just working to fix this real quick, so just please bear with us. Hi, everybody. Thanks for bearing with us. Just working right now with Alice to reconnect her microphone. Just hang tight, and it should just be a little bit longer.
Okay, I should be back. Am I back?
All right, you're back. Thank you very much.
Okay,
And thanks
thanks.
everybody for
I'm
being
sorry.
patient.
Yeah, my internet just completely dropped out for about a minute, but it took me a minute to get back into the system. Okay, I'm back. We trust that we will have no further technical problems. Um, okay, so who's protected? Everybody, employees, job applicants, unpaid interns, independent contractors, vendors, suppliers, random members of the public. If you're human, you are protected. Let's see. Alex, let's see, I am not able, okay, there we are. For a minute, I was having some
Okay,
difficulty getting
fantastic.
getting the power.
Great. Yeah, if you run into any more issues, let me know and I can move the slides forward, but I think it's
Okay,
coming through
thanks.
all clear now.
Thanks. Okay, I think we're good. Okay, let's move on to the employer's legal responsibility. The employer has 4 general responsibilities when it comes to sexual harassment. Responsibility number 1, take all reasonable steps to prevent and deter harassment. That's why we're here right now. We want to make sure you know what your legal rights and responsibilities are when employees are being onboarded into the workplace. We want to make sure the employees are onboarded correctly, that they are informed of their rights and responsibilities as well. Responsibility number 2, take all reasonable steps to stop harassment if it occurs. If an employee reports harassment, or if a supervisor or manager observes harassment or has reason to believe that it exists, at that point, a legal obligation is triggered on the part of the supervisor, the employer, really, to take reasonable steps to stop harassment. Now, this doesn't mean you need to take you need to go DEFCON 1 on everything. Sometimes reasonable steps might be as simple as going up to the offending employee saying, hey, cool it, that's not okay, and then documenting the incident. But make sure that if you are a supervisor, that when an employee reports it, if you see something, do something. As an employee, be aware that if you report harassment to a supervisor or a manager, they have to do something. If you go to the boss and say, hey, boss, I'm being sexually harassed, but don't do anything about it, they are required by law to say, I cannot comply with that request. The third legal responsibility is to investigate claims of harassment brought by aggrieved employees. Again, if you see something, do something. If you're aware of something, do something. It's a legal obligation. Every once in a while, we'll hear about an employee who goes to the supervisor and says, hey, boss, I'm being sexually harassed, but don't tell anybody. I don't want anybody to know. I just want you to know. And again, the supervisor is required by law to say, hey, I cannot comply with that request because you've just triggered a legal obligation on my part to investigate the claim. And investigating the claim may involve a report to the Equal Employment Officer or to HR. If the harassment is severe enough to be a violation of the criminal laws, law enforcement may need to be brought in. Now, this doesn't mean you're going to make it the subject of water cooler gossip. The supervisor is going to do everything in their power to keep this out of water cooler gossip and to keep it as confidential as possible. But the supervisor cannot promise complete confidentiality because an investigation may have to take place. The fourth obligation, and this is an important one, is the employer is legally obligated to protect employees who complain about harassment against retaliation. The employee does not have to file a formal complaint to be protected. If they say, hey, this makes me uncomfortable, or hey, I don't like that, or hey, boss, I'm being sexually harassed, that is enough. That is protected conduct. They cannot be retaliated against. As an employee, know that you are protected. As a manager or supervisor, make sure your employees are informed and told that they will be protected. When they come into your office, say to them, thank you for telling me, and I want you to know that we'll protect you against retaliation. Let them know they're safe. So, I said a few minutes ago that you are all protected by virtue of your status as human beings. By virtue of your status as employees, you are also potential harassers who are capable of committing employee misconduct. And sometimes I need to talk to you in your capacity as people who might cross the line. This is one of those slides. Be aware that there are consequences if you cross the line. One of those consequences is that you have just engaged in employee misconduct, and you can be disciplined up to and including dismissal from service. The other consequence is that you can wind up on the receiving end of a lawsuit. Now, 30 years ago when I was in law school, this was unheard of. Victims only ever went after the deep pocket. But these days we are finding an increased trend nationwide where victims are seeking to make individual harassers accountable for the harm that they've caused. And we're finding lawsuits for things like assault, battery, defamation, property damage, intentional infliction of emotional distress, things like that, where the harasser is being brought into court in their individual capacity as well. So again, be aware that this is an increasing risk, and this makes it even more a line that you do not want to risk crossing by accident. Let's stop just briefly and summarize a few points that we've already made. First, hostile environment discrimination is unwelcome conduct that is based on an employee's membership in a protected class, and employees in all 14 protected classes are protected against discriminatory harassment. Now let's move forward. I want to distinguish between two thresholds. I call one of them the lawsuit line. I call the other one the do not cross line. We are talking about a spectrum of behavior. This is not like a light switch that is either clearly on or clearly off. We've got a range of conduct. Some conduct in the workplace is totally safe. Good morning, how are you? You did a fine job on the XYZ project. And then as we become casual and incautious, we sometimes slip into a danger zone. Hey, baby, looking hot today. Ooh, get any action over the weekend? Here, let me tell you my latest not safe for work joke. And then we slip even further into conduct that is absolutely lawsuit. Sleep with me and I'll give you a raise. When we've got a range of conduct here and the line between safe and lawsuit does not have a clear delineation, we want to be really careful. Now, many of the cases that I'm going to talk about, and I will be using some real world lawsuits and cases, when I cite things that the court says, they're talking about the lawsuit line. The lawsuit line, of course, we don't want to cross. That's where we not only get sued, we lose the lawsuit. But that's not the line that we're going to use to govern our behavior. The line that we will use to govern our behavior, the do not cross line, is at the absolute edge of the safe zone. We are never even going to enter dangerous. We want to keep our conduct very safe for a number of reasons. One reason, of course, is it's just plain the right thing to do. We want to be doing the right thing. Partly because that's where your employer has located it as a matter of internal policy in the workplace. Partly because it's better for workplace morale. As a general matter, people are going to be happier, and you're going to have a more positive, more productive workplace if people are in an environment where everyone is respected. Partly we're going to do this because you don't want to become the subject of a workplace investigation. If you get too close to the line, an unusually sensitive coworker might file a complaint. Even if you are ultimately exonerated at the end of the investigation, you don't want to go through that investigation. These investigations are not fun. They are not pleasant for anyone. And then finally, you don't want to risk crossing the line by accident because the consequences can be severe. In my experience, a high proportion of employees who wind up getting called on the carpet are people who are honestly unaware that they crossed the line. They got a little casual, they got a little sloppy. They thought the people in the workplace were friends and they started acting buddy-buddy like they might act over the weekend. And then all of a sudden, they learned the hard way that that joke wasn't funny, that that conduct wasn't appropriate for the workplace. And they wind up like Sad Bunny here, sitting in the boss's office saying, but I was only joking. You don't want to be Sad Bunny saying, I was only joking. You want to be the one who doesn't cross the line by accident. And again, as a manager, you want to make sure that the employees you supervise realize where that line is so that they don't cross the line by accident. We want to make sure our employees are properly trained. Let's move back to the lawsuit line. The United States Supreme Court has given us some assistance here. The court tells us that a hostile work environment is created when the workplace is filled with discriminatory intimidation, ridicule, and insult that is sufficiently severe or pervasive to alter the conditions of the victim's employment and create an abusive working environment. This severe or pervasive line is a threshold. It does not represent the entire possible universe of harassment. The universe of possible harassment we might conceive of as being a two-dimensional plane, where one of the axes is severe and the other is pervasive. Some conduct is severe, more severe, medium severe, less severe. Some conduct is more or less pervasive. Some workplaces, it's happening all the time, all over the place. Everybody's doing it. That's pervasive. Other workplaces, it's kind of medium pervasive. Other places, it's maybe a one-off situation. And then we take our two-dimensional world of possible sexual harassment and we superimpose the severe pervasive threshold to tell you where you've got the lawsuit. Well, the lawsuit is all on the wrong side of the line, but please note that there is no green on my chart. Even if sexual harassment is not severe and not pervasive, the one-off that's just a rude remark, it still is not okay. Just because it's not a lawsuit does not mean that it's okay. In the world of severe, I divide the world of severe, which again, it's a spectrum. I use two general categories, what I call the eye rollers, the stuff that makes you roll your eyes and say, she's Louise, did you graduate from kindergarten? And then the stuff that's really bad. The stuff that even if it happens only once, maybe you've got a lawsuit. Severe is stuff that is physically threatening as opposed to an offhand remark or comment. Severe is conduct that is humiliating. Severe is something that interferes with the victim's work performance. Severe is something that harms the employee's psychological well-being. And then finally, when the harasser is a supervisor, the conduct is automatically bumped up on the severe scale because we all know that it's a lot harder to complain about harassment and to file complaints and get things investigated when the harasser is a supervisor. So that's the sort of thing we're looking at here. As an example, there was a case, this is a private sector case out of Florida some years ago, where this is a, as I say, private sector case. This is an air conditioning factory where two employees on the shop floor, one male, one female. The male employee propositioned the female employee. She told him to get lost, went to her boss, complained to the supervisor, and then the supervisor effectively said, sleep with him and then he'll stop bothering you. We do not recommend this. The employee then returned to the shop floor, knowing that she was not going to get any help from management, told the harasser to get lost again. He became angry, punched her in the face, threw her onto a conveyor belt where she was struck by an air conditioning unit that was coming down the line. Well, how many elements do we have severe do we have here? We have something that's physically threatening. In fact, it's workplace violence. We have something that is humiliating. We have something that interferes with the victim's work performance. She missed some work because she was physically injured. Her psychological well-being was harmed in a serious way. She developed post-traumatic stress disorder. And although the harasser was not a supervisor, she knew that the supervisor was not going to do anything about it and that the harasser had the supervisor's backing. We have here a case where if it happens only once, the victim has a viable claim for sexual harassment. The real case went to jury trial, and this is a 7-figure verdict. What about pervasive? The pervasive standard acknowledges that even the little stuff, if it happens a lot, gets really old really fast. Now, a few years ago, oh, excuse me, I'm just going to grab a drink for a second. Okay, a few years ago, in sort of the early days of COVID, I found this exchange on Quora. Somebody writes and posts a question. Would you be offended if a male coworker said wearing these masks is like wearing panties on my face? This is an eye roller. It's a one-off. It's a did you graduate from kindergarten, right? But look at the responses we're getting. One person responds, maybe not offended, but certainly uncomfortable. We've got an employee here who is being placed in a situation that we shouldn't place them in. This one-off eye roller immature comment might make somebody in the workplace uncomfortable, and then they have to decide which makes them more uncomfortable. Am I more uncomfortable speaking up and saying, cut it out with those inappropriate jokes? Or am I more uncomfortable with the thought of confronting somebody in the workplace and maybe being afraid that everybody in the workplace is going to think I'm a nerd because I complained about an obnoxious joke? We don't want people to be placed in that situation. And then look at the second comment. Here's another reason why, again, we don't want to be the first person to put this kind of puerile joke in the workplace. Somebody else says, I would not be offended. I would probably laugh and ask him if he wears panties on his face often. We have someone here who is willing to continue the joke, to take it to the next level. And then we've got a situation here where what started off as this one-off eye roller has taken a step on the road to becoming pervasive. Some kind of a work environment where everybody's telling raunchy jokes and it's happening all the time and you can't get away from it. We don't want to be the person who puts that 1 or 2 or 10 drops in a bucket, because at some point the bucket will be full. And again, this is another reason why if you're a supervisor or a manager, you want to nip this stuff in the bud. Just kind of let people know that it's not okay to go around being with those obnoxious jokes. Let's move forward and get some more help on the definition of what a hostile environment is. Again, we're talking lawsuit line here. We're getting some help from the United States Equal Employment Opportunity Commission. This is the federal agency that is charged with enforcing the federal anti-discrimination laws. The EEOC, the Equal Employment Opportunity Commission, defines a hostile environment as consisting of unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature, when such conduct has the purpose of interfering with an individual's work performance or creating an intimidating or offensive work environment. So we're talking about something that is fairly serious. It has to be serious enough to interfere with the job. And we've got this language here, conduct of a sexual nature. Now you're sitting there saying, hey, wait a minute, Alice. Half an hour ago, you went over that slide that said this, the stereotype of sexual harassment. You said it didn't have to be of a sexual nature. And that's right. I'm glad you were paying attention. This definition is correct, but it is not complete. There's another part of this definition, and we're going to go to the Colorado anti-discrimination statute to get that second part. The Colorado anti-discrimination statute says harass means to create a hostile work environment based upon an individual's sex. Please note, nothing in this definition requires sexual harassment to contain any overt sexual content. Now, it happens that federal law also works the same way. I didn't give you the cite on that. But any hostile work environment based upon an individual's sex. So what we have here is an either-or test. Returning to the EEOC's definition, if it's conduct of a sexual nature, it is sexual harassment. Part of what this means is we address the issue of what we call the equal opportunity harasser, the one who tells the raunchy jokes to everybody in the workplace, the one who sends that not safe for work joke to everyone in the workplace through the email system. That kind of stuff. If you're exposing everybody in the workplace to conduct of a sexual nature, you can't get out of a sexual harassment complaint by saying, oh, well, I'm an equal opportunity harasser. I harassed everybody. Because the EEOC says if it's conduct of a sexual nature, it's sexual harassment. But if it doesn't have any sexual content, and you're merely mistreating someone based on their sex, that is also sexual harassment. Name calling, bullying somebody, that kind of stuff is also sexual harassment. So be aware that that's an either-or test. The next point we want to make is that the harasser's motivation for engaging in harassment is irrelevant. And this kind of ties into it doesn't matter if it has sexual content or not. It also doesn't matter whether it's motivated by sexual desire or not. There was a case a few years ago. This is a California case, Sacramento, California hospital, where a female physician assistant was having trouble with two doctors that she was assigned to work with regularly. The case got a certain amount of media attention in the Sacramento area where I live, and the media called doctor number one the horny doctor because he had never learned the phrase good morning. He typically greeted people by saying, I'm horny. We do not recommend this. He would go into the operating room, gowned, gloved, surgical implements in his hands, performing open heart surgery, and still somehow managed to grope the operating room staff. And then he would regale them with stories of his sexual fantasies, many of which concerned Shania Twain and Ashley Judd. He was a huge fan of both singers. In the course of the grabbing and the groping and the Shania Twaining and the Ashley Judding, he sometimes became distracted, and there were incidents involving nicked internal organs causing harm to patients. The physician assistant complained about all of this harassment and all of this other behavior. She didn't like the grabbing and groping. She also didn't think that nicked internal organs was a good idea. The hospital did nothing. Doctor number two was not motivated by sexual desire. He was just really bad-tempered. Doctor number two was an unusually aggressive surgeon. He used unusually aggressive surgical procedures. And when the physician assistant counseled restraint, he typically would say, "Stupid chick, you operate like a girl." And then he would continue with the overly aggressive surgical procedures with the consequence that some patients were harmed. The physician assistant in this case is of Middle Eastern origin. Doctor number 2 also sometimes called her Al-Qaeda or ISIS. The physician assistant complained about all of this behavior. The hospital did nothing. Eventually, the PA got a reputation for being a troublemaker and she was fired. At that point, she hired a lawyer, sued the hospital, and other complainants started coming out of the woodwork. They had former employees coming back in airplanes, flying from as far away as Canada to testify against these 2 doctors. And the trial went on for 2 months. After a 2-month trial, the jury ultimately returned a verdict of, in round numbers, $168 million. At the time, this was the largest single plaintiff verdict in a sexual harassment case in the history of the country. For our purposes, it stands for the proposition that it does not matter whether the harasser is motivated by sexual desire or by hostility. Let's move on to same-sex harassment. I said a minute ago that it doesn't matter what the harasser's motivation is. The Jody On-Call case from 1998 represents a watershed moment in the world of same-sex harassment. It took place in a location that we don't normally associate with sexual harassment, namely an offshore oil rig where all of the employees were male. So far as the record shows, all of the employees on the oil rig were straight men. Mr. On-Call was subjected to serious harassment of a sexual nature. He filed a lawsuit. And the employer did everything in its power to get out of liability. Hey, wait a minute, this is male-on-male harassment. Men can't sexually harass other men. The Supreme Court said, oh, yes, they can. But the victim was straight. The Supreme Court says, we don't care. But the harassers were all straight. The Supreme Court says, we don't care. But none of the harassment was motivated by sexual desire. It was all just a bunch of horseplay, says the employer. And the Supreme Court says, we don't care that none of the harassment was motivated by sexual desire. And as to your claim that it was just horseplay, well, tomato, tomato, potato, potato, you say horseplay, we say sexual harassment. And the employer's on the hook for a very large amount of money. Nationwide, about 1 in 6 sexual harassment complaints are filed by men. That number has been pretty stable over the past decade or so. Again, managers, supervisors, from your perspective, what does the on-call case mean? It means keep your eyes open for sexual harassment that might not fit the stereotype. Let us move on to some LGBTQ issues. I said earlier that everything that we're saying today applies to all 14 of those classes of people who are protected by law. There are a few specific things that come up in the LGBTQ world that I just want to mention quickly. One of them is double standards. Things like if people have photographs of the significant other on their desk, if I can have a picture of my male significant other, my coworkers, regardless of whether they are male or female, need to be able to have pictures of their male coworker on the desk. Wedding pictures. If I can have a picture of my wedding on my desk, everybody else in the workplace gets to have a picture of their wedding on their desk. If there is an activity that people are in, that workers are invited to outside of working hours, connected with the workplace, and significant others are welcome, then all significant others have to be welcome. Pronouns and forms of address. Call people and refer to people by the pronouns and forms of address that they prefer. That's just common courtesy. Restrooms. A transgender employee is in the restroom for the same reason that everybody else is. They got to have a place to go safely and securely and privately, just like everybody else. if the issue comes up and somebody says, I don't feel uncomfortable sharing a restroom with the transgender coworker, then the one who is uncomfortable is the one who gets to wait in the hallway or go down the hall or use the unisex. You cannot require the transgender employee to be the one who goes down the hall. Few additional legal standards very quickly. Objective and subjective test. The legal standard for what is harassment is both an objective test and a subjective test. It is objective in the sense that the behavior the person is complaining about actually has to be offensive. It is a subjective test in the sense that the victim has to have actually been offended. When we talk about whether behavior is objectively offensive, we use a reasonable victim standard. This is the standard of a reasonable victim who stands in the demographic shoes of the actual victim. If the victim is male, a reasonable male. If the victim is female, a reasonable female. And then remember, we've also got race, color, religion, disability, national origin, ancestry, military veteran status, all of those other protected classes, same thing. A reasonable victim is the person who stands in the same demographic shoes as the actual victim. Third-party victims. Be aware that a third-party victim, that is someone who is merely an observer of the offensive behavior, can, under some circumstances, be a person who has a valid claim. If you're standing around in the break room with your 3 friends and everybody's telling raunchy jokes and you all like the raunchy jokes, it's still not okay because somebody else might walk into the room and they'll be offended. The break room counts. The parking lot counts. When a bunch of you all go out to work together or out at work and you all go out to lunch together and it's connected with the workplace or it's the office party, that counts too. Conduct that occurs when you're off duty and even away from the workplace counts as long as it's connected to the workplace. So be careful at things like office parties. One of the things that happens nationwide, every January of the world, there is a nationwide spike in sexual harassment complaints being filed, and they get filed as the result of office parties during the holiday season when people got plastered and started groping each other. So watch the off-duty conduct. Be aware that the break room, the parking lot, and all that kind of stuff also counts as being part of the workplace. I want to go very quickly over a few danger spots. I have given you a photograph of a beautiful azalea. You may have one growing in your yard. The reason I gave you the azalea is because very few people realize that it is a toxic plant. If you eat it, you can get sick or die. The kind of behavior that gets people in trouble in the workplace is not usually behavior that's obviously inappropriate, like propositioning somebody in the workplace or punching them in the face. People are more likely to get into trouble with behavior that is closer to the line because, like the azalea, it is less obviously poisonous. Let's talk about some physical harassment. Again, grabbing, groping, workplace violence, you don't have to be told that those are not okay. But people do sometimes need to be told that horseplay is not okay. Giving somebody in a wedgie in the workplace, it's very inappropriate. It also can be sexual harassment because you're treating someone in a way that, you're touching them someplace you shouldn't. Hugging, be careful with hugging. When it's huggers versus non-huggers in the workplace, the non-huggers win. A lot of people don't like to be hugged. They're not comfortable being hugged. We don't want to put them in a situation where they have to say to you, I'm not comfortable being hugged. So we have a no hugging rule. Invading people's personal space, getting too close to them, invading their space bubble. Be aware that your coworkers might have space bubbles that are slightly larger than your own. In this current era of COVID, we've adopted kind of this make it the length of a yoga mat standard. It's probably a pretty good idea in most cases. Be careful if you're in an office where furniture, cabinets, tables are close to each other. Give your employees that you work with plenty of space. Verbal harassment. It's going to be a real danger spot because some people don't even realize the line exists. Sexual slurs are not okay. Racial slurs, ethnic slurs, that kind of stuff does not belong in the workplace. Inappropriate conversation about sex, again, leave it out of the break room. It doesn't belong in the workplace. Personal labels. People should be referred to and addressed by their names. If you don't know their name, use a job title. If you don't know a job title, hey you is better than saying hey chick. Even better, how about good morning or may I help you? Unless your coworkers have extremely unusual names, your coworker is not named Honey, Sweetie, Baby, Chica, or Hot Lips. A lot of people don't like being called Honey, Baby, Sweetie, Darling in the workplace. Call people by their names. Another danger spot is nonverbal harassment. Gestures, I'll let you imagine what they might be. Practical jokes can cross the line. And obviously things like stalking and staring. You don't want to be following people around in the workplace or out of the workplace. Calling them, texting them, not appropriate. Staring, giving somebody the elevator eyes, it gets very creepy very quickly. When I do live training with live human beings, what I would be doing at this point in the presentation is walking up to a convenient victim in the front row and just staring at them, like their forehead. I did this 2 days ago in a live classroom, and people reacted in less than a second. My poor victim, it was less than half a second before he was giving me a funny look, and so was everybody else in the room. Staring gets very creepy very quickly. Inappropriate visual displays. If you have a computer in the workplace, if you bring an object into the workplace, your briefcase, your backpack, your toolbox, if you have decorative items up in the workplace, pictures on your cubicle wall, everything that you bring into the workplace, make sure that you remember it's an object you have brought into the workplace. Keep it professional. Keep that screensaver professional. Keep that lock screen on your phone professional. As we are telecommuting and have home offices, we've all had at least one opportunity, I'm sure, to see someone who has accidentally left something in the background that didn't belong there. If the item that didn't belong there is a can of Coke left on the kitchen counter or a teddy bear, that's only mildly embarrassing. But it could be worse. Take a quick look before you telecommute. Just take a quick look at what's behind you. Make sure everything is something that it's okay to have. Even if you plan to use a virtual background, we all know that sometimes those things drop out. All right, so we've done everything we can to prevent harassment. We've trained our employees. We've supervised our employees. We've onboarded our employees. We've set a good example, and then, oops, something happens anyway. What do we do now? Well, the first thing we want to do is we want to report harassment very quickly. It needs to be reported internally, and we want to encourage people to do it as quickly as possible. Under Colorado state law, the Colorado Anti-Discrimination Act actually requires an internal complaint before the victim can file a lawsuit. The statute provides harassment is not an illegal act unless a complaint is filed with the appropriate authority at the complainant's workplace and the authority fails to initiate a reasonable investigation of a complaint and take prompt remedial action if appropriate. So the employer has this chance to get out of it by responding appropriately to the complaint. Now, federal law doesn't actually have a statute like this, but there is federal case law that accomplishes almost the same thing, where under federal law, if the victim fails to complain, they remove from themselves the opportunity to get a wide variety of remedies that would otherwise be available if they had complained internally. So the victim should complain internally. And we want to encourage our employees to do it, as I said, as quickly as possible. The United States Supreme Court has told us that although Title VII, and by extension all other anti-discrimination legislation, seeks to make persons whole for injuries suffered on account of unlawful employment discrimination, its primary objective is not to provide redress, but to avoid harm. We're trying to avoid harm. We avoid harm by encouraging employees to report quickly, and then by responding quickly to nip this stuff in the bud before it becomes serious. We don't want our employees to be exposed to a workplace that's serious enough to give them a lawsuit. We want to have the workplace be one where people are respected in the first place. So the employee has to file their complaint internally. The internal complaint will take place. That's going to depend on the policies of your individual agency. In most cases, that can be resolved. But in the interest of, we've only got 4 minutes left, we're going to move forward to external complaint filing procedures. What do you do if the internal complaint fails? At that point, the employee can file a complaint with the Colorado Civil Rights Division, the state agency, or can file a charge with the United States Equal Employment Opportunity Commission, the federal agency. It doesn't matter which one they file with. You can file with either because the two agencies have a work sharing agreement. In both cases, the charge or complaint needs to be filed within 300 days of the date of discrimination. Now, if you received this training a year ago or 2 years ago or 3 years ago, you heard a different deadline for the state. Today, it is 300 days from the date of discrimination. That's a fairly recent change in the law. Usually, the federal or state agency can resolve the problem, but if they cannot, they will issue the victim a notice of right to sue, commonly known as a right to sue letter or 90-day letter. It's known as a 90-day letter because after you get the letter, you have 90 days to file your lawsuit. Now, I want to give you one caveat about this slide here, and that is that it's not accurate yet. It will become completely correct on June 5th, 2023, 3 weeks from today. This is a recent change in the law. So if you were sexually harassed between mid-July of last year and August 9th of last year, there's this 3-week period where you're still subject to the 6-month statute on state law claims. But from June 5th and moving forward, 3 weeks from today, the rule will be 300 days. It's exactly the same for both state and federal. I thought it would be better to give you the law that's going to go into effect 3 weeks from now than to stick you with some old law that won't be accurate 3 weeks from now. So treat that as being, unless you were sexually harassed in late July of last year, a 300 days deadline to file your complaint or charge. So you got about 10 months. It is a tight deadline. As we said, we're trying to nip this stuff in the bud, get it taken care of before it becomes serious. Oh dear, we're almost out of time and I've got to talk about retaliation. I may be taking you 1 minute over. Both federal and state law prohibit employers from discriminating against or harassing individuals who have availed themselves under their rights under these anti-discrimination laws. If you oppose a charge of discrimination, hey, that makes me uncomfortable. That's a raunchy joke. That's not appropriate. Get your scummy hands off of me. That's opposing a practice that violates the anti-discrimination laws. It is protected. If you file a charge or complaint internally, if you file it externally, you're protected. You don't have to be the victim. If you testify, assist, or participate in an investigation involving someone else, or help someone else with a proceeding or a hearing or testify, those are all protected behaviors. We need to make sure that we know that's the law. We need to make sure that the employees we supervise know that that's the law. Bottom line to all of this is respectful behavior. If we treat the people in our workplace with respect, if we demand respect for others and demand respect for ourselves, we don't need to worry so much about the weeds of the specifics I've been talking about for the last hour. We are now at the end of the time, and I thank you for your attendance and attention. If you have any final questions, I'll remain on the line for another minute. I do notice that Diane Criswell has provided us with a statutory citation for that updated statute that I gave you, Senate Bill 23-172. She says passed the Colorado General Assembly and further amended CADA. So thank you for that, Diane.
All right, fantastic. Alice, thank you very much. We will just wait on the line for a little bit longer in case there are any questions. I want to thank everybody for attending here today, all our membership for being here across the state of Colorado. A really excellent session. This was, again, presented by CPS HR Consulting. We partner with them at the Colorado Special Districts Pool. If any members would like to learn more about the services they provide and our other HR services that we have for our membership, you can head on over to csdpool.org/HR. The CSD Pool provides all of our members with 10 hours of free consultation through CPS HR Consulting. So that's available for situations where you need more advice on pressing legal issues or just general HR concerns. I see we have one question coming through here, Alice, from Stephanie. She's asking, could you point me to a place to find language? Yeah, perfect.
Yeah, onboarding documentation. That's a very good question, and I wish I had a very good answer to it. I don't have in my little quiver of tricks a specific place to include for onboarding documentation, but let me give you a general reference, and I'll tell you, this is just one that I use all the time for my own reference when I'm looking for some good language, and that is the United States Customs and Border Patrol. If you look in the if you just go to the website of United States, what's CBP part of? Customs and Border Patrol is part of, Homeland Security. CBP has some really, really good anti-discrimination policies that are available on their website, and it's a wonderful cost-free reference for almost anything. So that's one that I kind of use if I need to look up and say, hey, let's get some good ideas. I go to Customs and Border Patrol. And then another one that I've recently discovered, and I don't think they have any onboarding stuff, but they've got some terrific policies with regard to investigating claims of sexual harassment. And it's just a weird one, is in California, the Yurok Indian tribe. That's YUROK. So the California Yurok tribe, if you go into their materials, they've got some terrific policies on investigations. And that's one that I've been planning to do some downloads and start stealing for my own use, because they've got some real good policies on that.
Okay, great. Yeah, and I also recommend checking out the resources. The HR helpline that we offer our membership through Zywave also has a lot of sample policies in there as well. And we'd be happy to talk to you more about that resource, Stephanie, if you're interested in that. All right, well, we'll hang out for a little bit longer. If there's any other questions to come through, go ahead and type them now. Otherwise, just want to point out that we have our calendar of webinars on our website as well, csdpool.org/events. And we will be planning a employment law update shortly this year. It's not currently up on our calendar, but you will be able to find a few other HR-related webinars and safety and loss prevention webinars that are scheduled currently. So go on head over to our website for more information there. I don't see any other questions coming through, so I just want to thank you again, Alice, for putting this excellent presentation on today.
Okay, well, thank you for all of your help, Alex, and thank you all to the rest of you for your attendance at today's presentation.
All right, great. Again, thanks everybody for joining us today, and we will see you next month for the next presentation.